So this is European Code Law versus British Common Law, the Implications for Business Executives by Brian Bateman, Sharon Hatton, and William Smith. So first I'd like to start out just by explaining a little bit about the difference between common and coded law. So common law is generally uncodified. There's no comprehensive compilation of legal rules and statutes. It's largely based on precedent, meaning the judicial decisions that have already been made in similar cases have a heavy weight in current cases. This means that judges have an enormous role in shaping American and British law. Common law is largely decided on by the judges, who have this power to basically decide laws and rules based on what other judges decided before. Whereas in coded law, otherwise known as civil law, it is codified generally, and there is a comprehensive, continuously updated legal code that specifies all matters capable of being brought before a court. So in codified law, the judge's role is much smaller as far as how much weight they have. They have no role in actually making laws or changing laws. The judge's role is only an enforcer. So where in common law, the judge might be analogous to the king, who can make all the rules, in coded law, the judge really is just analogous to an enforcer. They don't have any ability to change those laws. And so a quick analogy on that might just be during family game night. If you have a family set of rules, that would be the common law. So if you're playing Uno and your parents are enforcing your family rules, that would be your common law. Whereas in coded law, you would be following the rule book word for word. There would be no changing on how you use a skip or reverse. This graphic here shows the use of common law versus the use of civil law. You'll notice that the US is one of very few places that uses common law, and so it's a little bit more familiar for us. We do have Louisiana, which uses both common and civil law due to its interesting history, but it is very important for American businessmen to know, and women, to know civil law because it is used mostly all over the rest of the world.
With an understanding now of the differences between common law and civil law, our next step is now to kind of make clear to you why it's so important to understand those differences beyond just the minimal understanding of that they're different. There are a lot of points that we could pull from this, but we narrowed it down to two. The first point being legal costs. We know that legal costs are already a significant expense for organizations. And according to our research, there's no exact figure due to cost accounting methods, and that you can incur expenses at different time in different quarters and different years. But it's estimated that the total cost of litigation for companies is around $210 billion, which is equivalent to 1/3 of after-tax profit of the Fortune 500, far exceeding CEO compensation. And I want to point out here that this figure is just litigation costs. It is not total legal costs. So there is a direct economic benefit to understanding and a motivation to understanding these differences. As if you understand them, you can be much better at trying to keep your legal costs down. The second aspect of that is that understanding the differences between common and codified civil law will allow your organization to conduct more accurate due diligence when you're deciding whether to expand internationally. As you do your due diligence and you think about your product and where you're going to place it, the country and the cities that you want to work in or to sell your product in, you're going to consider local custom traditions. You're going to consider local rules and regulations, city codes, and you also have to consider the laws of that state and city. And with a better understanding of the differences between them, then you'll have an advantage in being able to conduct your accurate due diligence and be able to have an accurate measure of your costs as you decide to move into conduct business in these new areas. The general rule we found in our research is this concept of know before you go. The more accurate information you can put together, the more successful you're likely to be. Continuing on that, if you don't understand or you have minimal level of understanding between the difference between common law and codified law, as there can be difficulties in the way that you run your business and the impacts to your business. You, by not having full understanding there, you're going to incur costs associated with the unforeseen legal issues that arise. And those unforeseen legal issues, they will disrupt the natural flow of your business and create issues that you don't want to deal with. It was kind of a humorous example, but it's real life and helps us understand the importance. One common area of mistake between common and codified laws and employment law. Quick side note story is there was an employee in France who was attempting to pass off the purchase of car tires and other personal expenses on his business expense report. The employer identified this on the expense report, carried out its investigation for the most part in compliance with French law requirements, and at the conclusion of that investigation, they terminated the employee. Well, after the fact, they found out that that there was a local French law that required you to terminate your employee within 2 months of discovering the misconduct. And they were outside that 2-month window. And as a result, they were forced to pay that employee $180,000 in damages. So not understanding can have a financial impact and also a personnel impact. Another big area that proliferates business, not necessarily business law, but international business everywhere that you go, is the concept of contracting. There are employment contracts and leasing for office space and contracts for the sale of goods and shipping. There's everything that we do is preceded by the formation of one contract or another. And the difference between contracting between common law and civil law is vast. And what's tricky is the terminology between the two overlaps. So if you are an American company with attorneys trained in the common law, they may be thinking they are competently practicing law and understanding the contracts that they're performing, when in reality, the terms might be similar, they're very different. As a quick example of kind of the difference. In America, for the most part, you have 3 elements. You have offer, consideration, and acceptance. And when you have those 3 elements, you have a contract. Your freedom of contracting is extensive. You can contract about whatever you want. The purpose of, the objective under common law for contracting is that you just want to set out the rights and obligations of the parties. You want to set forth damages, and you want to be able to predict with accuracy the outcome of this binding legal agreement to the extent that you can. There are causes of action which, they can come into play, but if no one raises the issue, then you move on and you complete the contract. In civil law, it's quite different. A lot of the elements overlap. They have different names, so that can create some confusion. But civil law has a much more sophisticated model for contracting with provisions that are based in codified law. They are set, and you do what they say. What's unique with civil law is the contracts are divided into different categories. And each category has a set of codified rules and regulations which govern which must be in place in order for that to be a valid and binding agreement. Without a full understanding of what those categories are and those elements that apply, you will not be contracting when you think that you are, and you will be contracting when you won't think that you are. So it can create a number of issues. Some examples of this are the concept of a unilateral contract. In common law, unilateral contract is a one-way gift. In civil law, unilateral contract is a contract about gifting. Also in civil law, you have what's called a gratuitous contract. Under the common law, you would think that would be a gift, but in the civil law, it's actually a one-sided contract, and there are some intricacies and complications within there that we don't need to get into, but it's important to understand. You must understand the framework in which you're working, or you are going to be binding yourself to agreements that you never intended to, or you will be thinking you have an agreement in place and you don't.
So we've talked a lot of material here, and you can dive a lot deeper into the difference between common law and civil law. But the most important thing to know for businesses is to know before you go, understand where you're doing business and the framework that they have, and to make sure you have a strong legal team that can help protect you as you enter into these markets. And it's also critical for companies that they can be benefited by understanding this topic. the first way is they can determine if they really want to expand internationally. Looking into the costs and the different structures and the frameworks, they'll know if it's really worth doing business in a different environment. Understanding all the legal systems can protect them from litigation. We saw it's very expensive. Companies spend a lot of money on litigation and legal fees every year. And that's important for them as they're doing their budgeting and they're looking at their legal expenses. Keeping their budgets tight and trying to minimize those expenses can make or break a company. With every complex thing, there's always a loophole. And with companies that are in multiple legal systems, they're able to choose and take advantage of the loopholes that they can find in the legal systems. They can pick, and they could go to court in one country and get a different outcome than in a different country. So having multiple legal systems can be an advantage for companies. And then the final point that can really help a company to benefit is it can enhance their negotiations. The more you know, the stronger you are. The more you understand all the complexities and the rules, you're able to present tighter facts, and that can enhance your negotiations to make sure that you're protected and that you get the outcome that you're looking for. We're thankful for your time as you listen to our presentation, and we're excited to see your comments on the class discussion. Thanks.